Which cryptocurrency is being attacked by the SEC after XRP? How long will crypto holders believe in Ripple? How much will XRP cost in mid-2020? 3. Investors who filed a class action lawsuit against Ripple 4 years ago alleging that XRP is a securities want to pursue their case. The parties in the Zakina v. Ripple action will be heard on April 26 in a federal court in California. According to an update published on Wednesday by Crypto Law, a regulatory news website for digital assets. The website also said that 500 people maximum should have access to the proceedings online. Statement. The hearing is for oral arguments on the question of certifying the class of XRP holders suing Ripple. Investor Bradley Sostak is serving as lead plaintiff in a case filed against Ripple and CEO Brad Garlinghouse by 2019 plaintiff Vladi Zakhinov and 2 other persons. After taking a significant loss on the sale of XRP in January 2018, Vladi Zakhinov filed a lawsuit against the defendants, alleging that XRP is an unregistered securities. Additionally, the plaintiff hoped to get the case certified as a class action lawsuit covering any and all purchasers of XRP. Defendants, however, argued that XRP is not a security and asked the court to throw out the lawsuit. Oral arguments on whether to certify the class of XRP holders suing Ripple will be heard today, as announced by Crypto Law. The plaintiff, Bradley Sostak, who owned XRP for 2 weeks, is asking to be lead plaintiff in the class and is asking to represent all XRP holders who either owned it and sold it at a loss or own it today, Crypto Law said. While his request has not yet been decided on, John Deaton, who had submitted an amicus brief on behalf of 75,000 XRP holders in the dispute, said that he plans to watch the proceedings. However, as Ripple fights out the lawsuit, the community is still interested in the outcome of the company's parallel fight with the SEC. Most of the papers have been submitted, thus a summary decision from Judge Annalisa Torres is possible shortly. In the meanwhile, the continuing litigation has created further uncertainty for investors who must decide whether to liquidate their shares or wait for a resolution. Nevertheless, most analysts feel Ripple might bag a victory, aiding XRP's ability to break new territory in light of SEC's seeming blitz on the crypto industry despite the absence of necessary laws. Although a resolution to Ripple's case against the SEC is expected soon, the company has been affected negatively by the ongoing delays. The repercussions of investors' dwindling confidence may be evident on-chain and in Twitter rumors. Early today, rumors started spreading on Twitter that Ripple and the regulatory body were due to meet in secret. Blockchain Daily, the initial source of these assertions, tweeted, "Pro-XRP attorney John Deaton shot down these reports as apparently false not long after the tweet." In addition, he said, "Attorneys for the SEC and Ripple might get together whenever they choose. They wouldn't choose a day a week from now and let the news slip." In my opinion, in response, Blockchain Daily agreed with Deaton, stating that his view was reasonable and that the website had not made up the tale. As the summary judgment keeps getting pushed back, we still don't know if there's any truth to the situation or not. Social media users have begun to speculate that the regulatory body received the summary decision due on May 6, and, seeing they were losing, decided to settle out of court. Based on the report, a ruling from Judge Torres was anticipated to be made in April. John Deaton said last month, "We are about 5 weeks since she delivered the Darbert ruling, and the summary judgment could come out any day now," signaling that supporters and investors are now waiting for the verdict this month. On May 6, we will have reached the 60-day threshold, at which point a decision may be made. In turn, this may have a significant effect on the fortunes of Ripple and XRP, both of which are struggling at the moment. Given the current regulatory climate in the United States and the industry's efforts to adapt to it, a fresh Supreme Court consideration may have far-reaching consequences for the future of the cryptocurrency market. For example, the XRP v. SEC case and the grayscale spot Bitcoin ETF might be profoundly affected by a change in the power structure of us regulators. An earlier judgment that grants rulemaking authority to agencies is being reconsidered by the Supreme Court. The lawsuit that might overturn a rule that gives entities like the SEC the ability to define their own powers will be heard by the U.S. Supreme Court, beginning in October 2023. The goal is to provide updated standards for how these institutions, such as financial regulators, should function. Therefore, if the new Supreme Court appeal limits the SEC's ability to define which cryptocurrencies are securities, it could signal a significant shift for the crypto ecosystem in the United States. A favorable ruling in the forthcoming summary judgment in SEC litigation was already anticipated by the XRP community. In December of 2020, the Securities and Exchange Commission, SEC, filed a lawsuit against Ripple Labs, claiming that XRP tokens were offered by Ripple and its officials as unregistered securities. Ripple, the third biggest cryptocurrency by market value, is accused by the SEC of raising $1.03 billion via unregistered sales of XRP, according to Ripple's defense. According to Ripple's defense, XRP is not a security but rather a cryptocurrency in the same vein as Bitcoin and Ethereum. In its most recent quarterly report, Ripple said the SEC had failed to persuade a judge to order the company to turn over confidential material. According to reports, the files in issue pertain to Ripple's legal opinion on whether or not XRP constitutes a security. Ripple asserts that the records would demonstrate that it did not willfully break securities laws. To add insult to injury, Ripple claims that the case's summary decision will be issued in the year 2023. A summary judgment is a pretrial judicial decision on the merits of a case. The summary judgment would decide whether or not XRP is a security in this instance. The lawsuit would be dropped if the court sided with Ripple. The lawsuit will go to trial if the SEC convinces the court to do so. If what Ripple says is accurate, it might end up being good for business. Ripple may have behaved in good faith and not knowingly violated securities laws, as shown by the aforementioned papers. In addition, the cryptocurrency sector as a whole stands to benefit greatly from a judge's ruling in favor of Ripple in the summary judgment. A ruling that XRP is not a security might pave the way for wider use of the cryptocurrency. Keep in mind that the case's fate is still up in the air. The lawsuit may be resolved by summary judgment in favor of the SEC, or it may go to trial. The SECs might still file an appeal even if the court decides in Ripple's favor. The legal struggle between Ripple and the SECs is expected to go on for some time, and the result is anyone's guess at this point.